And I want to talk about this case that came down this past week and get your thoughts on it, both of you, Tim and Frank. The case is Salisbury Engineering versus Consolidated Contracting Services, but it's a subpart of that case. There's a contempt order referred to as In re Mahoney, and we'll have a link to the case in the show notes. It involved attorney Paul Mahoney of Mahoney and Saul, and this was a typical business dispute. The opinion came down, and when the opinion came down affirming the result below, attorney Mahoney filed a petition for rehearing. And the Court of Appeal issued an order denying that petition for rehearing, which is not unusual. Petitions for rehearing are rarely granted. But simultaneously, the Court of Appeal set an OSC re contempt and highlighted some of the arguments that were made in the petition for rehearing, noting that the petition for rehearing did not cite a single statute or decision and didn't really have any substantive analysis. It basically used name calling. One of the things argued in the petition for rehearing was a suggestion that the court did not follow the law. An assertion in the petition for rehearing was that the court ignores facts, and that one of the statements made in the petition for rehearing was that the Court of Appeal indiscriminately screwed the losing party. So oral argument was held on that.
We all want to say it from time to time, don't we?
Most of us have that little voice, Tim, that says, don't say that in a petition for rehearing. So anyway, there was an argument held. No ruling was made on the order to show cause until the petition for review in the Supreme Court was filed and denied. And the minute the Supreme Court denied review of the underlying dispute, the Court of Appeal issued a scathing order that held that attorney in contempt. And it started with, we published this decision as a cautionary tale. You never want to receive an opinion that starts that way. And it talks about some of these arguments that were made in the absence of any substantive analysis. And it goes on to say, we are professionals, like the clergy, like doctors, like scientists. We are members of a profession, and we have to conduct ourselves accordingly. Most of the profession understands this. The vast majority of lawyers know this professional speech must always be temperate and respectful and can never undermine confidence in the institution. Cases like this should instruct the few who don't. If you think the court is wrong, don't hesitate to say so. Explain the error, analyze the cases the court relied on, and delineate the mistake. Do so forcefully. And then proceeded to find this lawyer in contempt. And I was just wondering, my experiences over the years is that, these personal attacks have started to increase, or maybe I'm just becoming more sensitive to it. In your experience, either Tim or Frank, have you noticed a decrease in civility in the appellate bar?
I don't think that I have. Georgia is a courteous place for the most part to practice law. There are practitioners who are guilty of over-the-top comments, typically about the other lawyer, not, as in this case, the court. So I haven't really noticed a lack of civility. You will see harsh language in briefs from time to time, and in my experience, that almost always works against the party using that kind of language. If you are credible and you have a reputation of honesty and clarity before the court will protect you. You don't have to protect yourself. The best way to diffuse that language is to show that whatever representation they're challenging is perfectly accurate, and let the court do what it's going to do from there. But yeah, I read that opinion as well, and it's such an over-the-top example that I don't know how useful it really is as a cautionary tale. I assume you don't frequently have attorneys imputing the courts themselves in their briefs.
Yeah, you're right, and even the Court of Appeal here acknowledged that. It said, thankfully, this kind of conduct does not come up much. It put that in a footnote, but so I thought that kind of undercut against the professed need to advertise that in a published decision as a cautionary tale. In my view, it seemed what really startled the court, maybe as much as anything, was how pointless and witless the attacks were, because they didn't seem to go anywhere. As the court was kind of belabored that there was no analysis given by the attorney. Didn't bother to say what facts the court got wrong, what law the court got wrong, didn't take up any of the analysis or cases offered in the opinion. And the Epictetus quote came to mind, by nothing is the rational creature so distressed as by the irrational. And I thought that the irrationality was really what perturbed the court.
Yeah, I honestly, I read this and my real reaction was sadness, because I obviously don't know anything about the facts of this case or any of the people involved in it. But the behavior seemed symptomatic more of maybe some personal struggles rather than a belief that this behavior was appropriate or justified. And we all know practicing law is a very stressful job, and after doing it for decades, so maybe there were more warranted measures there. Who knows?
I did think that the attorney got off easy with only $2,000. Probably more concerning was the referral to the state bar.
Yeah, he's going to have some MCLE classes in his future.
It is kind of interesting thinking about this. Two things occurred to me. It's such an extreme example that it hardly seems necessary to say, on this podcast or any other, don't do this. But one of the things that occurs to me that's kind of interesting is, there are not, as far as I know, any other organs of government that can say, don't impugn confidence in me, don't attack my integrity. That's a constitutional right with respect to the executive branch, the legislative branch. And I suppose outside of legal briefs, this lawyer would have been free to say all of those things, I assume, without sanction. It is kind of interesting.
Well, I'll go off on a very brief tangent on this. What occurred to me when the court went on a little bit of a discursive about the integrity of the court and went back to Francis Bacon and Cook and Black, about how it's just beyond the pale to call into question the integrity of the court. And I think that's all obvious and clear. But one thing came to mind was that the Congress at one point, when it enacted 42 USC 1983 to give causes of action against state actors, it did not include judicial officers. And at that time, judicial officers were among those who were denying African Americans, former slaves, the rights accorded them by law. And it was the judiciary who took it upon itself to find a judicial immunity where none had been offered by the legislature. And I thought, it just occurred to me when the court itself is saying, no, we are beyond questioning. Well, the Congress didn't think so. You're the one who keeps saying that you're beyond questioning. Maybe the public from time to time has a point. And this was not the right case to suggest that there is anything to impugn the court for, because the attorney here was just, I don't know if he was having a senior moment or something. He'd gone 50 plus years as an attorney, and I don't know where he thought that he could get away with this. But I just thought that maybe the court is overstating it just a bit. That the court's integrity is never in question. It just can't be questioned in this manner.
The other thing that occurred to me too, and I don't know how prevalent this problem is across the country, I have occasionally read appellate opinions that I thought were unfair to the lawyers, were gratuitous in either poking fun at or criticizing the conduct of the arguments of the lawyers. And I think that is the kind of thing that courts have to be so very careful about. I don't cite this. This does not seem to be an example of that. Let me just be clear. But I have read appellate opinions where I thought, you've got to be so restrained, because this is not a fight among equals. This lawyer can't punch back at you. If you want to have a private discussion where everyone can say what they think, fully and fairly, that's fine. But it seems to me that part of the judiciary maintaining respect for its integrity is being oh so careful in how it uses its power, to comment on lawyers and parties.
Yeah, that's a good point. One lesson that I drew from this case is I don't know if this particular lawyer was trial counsel. Sometimes when trial lawyers handle their own appeals, they are so fired up still from the loss at trial that they lose perspective. And without sounding overly marketing of ourselves, what a great opportunity for an appellate lawyer to come in and give a cold, sober reading of the record and bring down the emotion a little.
That's actually a very good point. I'm sort of it's like having a surgeon operate on his or her own family member. I understand that's not really done, so maybe there's something to that.
Yeah, that's a great analogy.